Hello, everyone. Let's talk about Chapter 7 and tort law. So, tort law is an act, and this is from that law.cornell website. A tort is an act or omission that gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability. So, we're really emphasizing civil as opposed to criminal. And tort, that's a funny word, but it's just this act or omission that gives rise to an injury. So it's spilling water on the floor and you slip on the water. That act is the tort, which gives rise to an injury. The person fell and hurt themselves and amounts to a civil wrong for which courts impose liability, so the store owner may be liable. And again, we're focusing on civil, not criminal. So criminal law, the intent for criminal law is to punish someone. But civil law, the intent behind civil law is to restore someone, okay? Not to punish, but to restore. So there's different classifications of torts. There's intentional torts, there's negligent torts, which we just talked about with the slip and fall, and then there's strict liability torts. So intentional torts, according to your book, is when an individual, quote, takes an action intending that certain consequences will result or knowing certain consequences are likely to result, end quote. So again, an intentional tort. There's intent behind the tort. Negligent tort, that slip and fall, just spilled a bucket of water, you were negligent, that's a negligent tort, carelessness. And then strict liability that arises from activities that are just inherently dangerous, activities that cannot be done safely. Now, with regard to intentional torts, you don't need to intend for the harm to result. You just need to intend for there just needs to be intent behind the action, and then that action caused harm. So with intentional torts, we're not concerned about motive like we may be for crimes. Let me give you an example, that mop bucket example. I may be careless and spill my mop bucket, resulting in a customer slipping and falling. That's negligent, okay? But I also may intentionally dump my mop bucket, resulting in a customer slipping and falling. I might not have intended for them to slip and fall, but I certainly intended to dump my mop bucket, and that's an intentional tort. Okay, so the intent does not equal the harm. You're not necessarily intending to harm someone. You're intending to do the act that resulted in the harm. Let's talk about intentional torts. Now, so we're back to talking about intent. Intentional torts against persons. These are intentional acts that harm a person physically or mentally. So let's first talk about assault. And we're not talking about a criminal wrong. We're talking about a civil wrong for which you're going to seek monetary damages. I mean, if someone assaulted you, you might go to the police and you might want them prosecuted. But here we're not talking about that. We're talking about you suing the person who assaulted you and trying to collect monetary damages. You are not trying to punish that person. You are trying to restore yourself. Now, the interesting thing about the civil wrong of assault is that no touching is necessary. And we talk about assault and battery sort of going hand in hand. But here we're just focusing on assault. And again, assault does not involve touching. According to your book, it's the fear or apprehension of an immediate offensive bodily contact. So it's the feeling of fear or apprehension, and that must be reasonable. So this idea of a balled up fist, you might not hit me, but you're threatening to hit me, so you are assaulting. I have a reasonable fear that you are going to hit me. That's assault. So now battery. Battery is the bodily contact. And so you can have battery without an assault, okay? Well, we think of them together all the time, but you can have each one separately. So you can have battery without an assault. In fact, interestingly, you don't even need to know you sustained bodily contact in order to have battery. So an example is Sleeping Beauty. And I've said Sleeping Beauty because I think this restatement, this example that I'm citing here from the restatement, sure sounds like Sleeping Beauty. A kisses B while asleep, but does not waken or harm her. A is liable to B. And then the restatement goes on in that comment to say, this affront is as keenly felt by one who only knows after the event that an indignity has been perpetrated upon him, as by one who is conscious of it while it is being perpetrated. Okay, so with battery, you have bodily contact, okay, but after the contact occurs, after you wake up or you realize later that the contact has occurred, you still have battery. So let's talk about some defenses to battery. And again, battery is that unwanted physical contact, okay? So those defenses are consent, self-defense, defense of others, and defense of property. Let's talk about consent. So remember that Sleeping Beauty example I just talked about. So let's say right before being kissed, Sleeping Beauty wakes up and consents to the kiss. Okay, that consent would be a defense to battery. She consented to being kissed. So she would not have a cause of action of battery against the person who kissed her because she consented to the kiss. Self-defense is another defense. And so here is a variation on the books example. You're in the parking lot after a BGSU football game and another student who is drunk starts swinging at you, and you push him and causing him to fall back and hit his head. Now, you potentially committed battery against that person, but your defense is you were acting in self-defense, okay? Self-defense is a defense to battery. How about defense of others? Well, you can use the same force, same degree of force that would you use to protect yourself. So if somebody is swinging at your girlfriend, you shoved that person, then that would be a defense to battery. And then defense of property. So you have an intruder come on your property, you can use, and the book calls it reasonable force to defend yourself, defense of property. So those are all defenses to the civil wrong of battery. Continuing to talk about intentional torts against persons, now we're going to talk about defamation. So with defamation, we're talking about libel, and we're talking about slander, and then slander per se. So defamation is, according to the book, quote, the intentional publication, communication to a third party, of a false statement harmful to an individual's reputation, end quote. So the intentional publication of a false statement harmful to an individual's reputation. Libel is defamation in permanent form, like a magazine or newspaper. It includes television and radios. Now here's a statement from the restatement second of torts. Defamatory pictures, caricatures, statues, and effigies are libels because the defamatory publication is embodied in physical form. So again, with libel, we're talking about defamation in a permanent physical form. Slander. Slander is defamation, but it's oral, okay? It's transitory. Here's again from the Restatement Second of Torts. The use of a mere transitory gesture, commonly understood as a substitute for spoken words, such as a nod of the head, a wave of the hand, or a sign of the fingers, is a slander rather than libel. Rather than a libel. And then you have slander per se. That is slander that's so harmful and egregious that general damages are presumed. Now, some defenses to defamation. The first defense that we're going to talk about is opinion. If the statement or utterance was nothing more than an expression of opinion, then probably not actionable defamation. So if you're just giving your opinion, if you're just stating your opinion on something, then that's probably not actionable defamation. Or that's a defense to being accused of defaming that person. You're saying, oh, I was just giving my opinion. Truth is also a defense to defamation. So if you say Rick is a convicted felon, but in actuality Rick is a convicted felon, then no liability for defamation. So opinion and truth. Some other defenses to defamation. Absolute privilege. So U.S. congressional debate. I'm sure you've seen in the news on C-SPAN or whatever, the congressional proceedings. Well, what congressmen say and congresswomen say to one another in a debate is covered by this absolute privilege. In other words, one congressperson can't accuse another congressperson of defaming them because there is an absolute privilege of what goes on the debate floor. Same way with judicial proceedings. And I think, in fact, I'm sure the book talks about this. We want people to be able to testify accurately in judicial proceedings. So that's a defense to defamation. Privilege, absolute privilege. Conditional privilege. This is, for example, like a job reference. So again, your book talks about conditional privilege. Here's a quote from the book. Under a conditional privilege, a party will not be held liable for defamation unless the false statement was made with actual malice. A statement is made with actual malice if it is made with either knowledge of its falsity or reckless disregard for its truth. The book goes on to state that the employer will not be held liable as long as the statement was made in good faith and was made only to those who had a legitimate interest in the information being communicated. So there's a real concern here, I believe, on the part of employers to give job references. Some employers do not want to let current employees give job references for former employees. And I'm assuming it's for concerns of liability. And then there's public figure privilege. Again, saying something about a public figure, an actor, and it's fine as long as there was no malice. Let's talk about several invasion of privacy torts. We're going to talk about false light, public disclosure of private facts, appropriation for commercial gain, and intrusion on an individual's affairs or seclusion. False light. Let's take a look at the Restatement Second of Torts. I have the citation there. One who gives publicity to a matter concerning another that places the other before the public in a false light is subject to liability to the other for invasion of his privacy if A, the false light in which the other was placed would be highly offensive to a reasonable person. I'm going to see that in a second. And B, the actor had knowledge of or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the other would be placed. So let me read to you an illustration that from the restatement that helps explain what we just read. Quote, A is a taxi driver in the city of Washington. B newspaper publishes an article on the practices of Washington taxi drivers in cheating the public on fares and makes use of A's photograph to illustrate the article, with the implication that he is one of the drivers who engages in these practices. A never has done so. B is subject to liability to A for both libel and invasion of privacy. It's false light. Public disclosure of private facts. Again, looking at the restatement second of torts. One who gives publicity to a matter concerning the private life of another is subject to liability to the other for invasion of his privacy if the matter publicized is of a kind that A would be highly offensive to a reasonable person, and B is not of legitimate concern to the public. So let's look at an illustration from the restatement second of torts. Quote, a motion picture exhibitor wishing to advertise a picture to be exhibited writes letters to 1,000 men in which he makes unprivileged and objectionable statements concerning the private life of B, an actress. This is an invasion of B's privacy. End quote. Appropriation for personal gain. You can see the citation at the bottom of the slide there. This citation was to a news report regarding Mayim Bialik, and hopefully I'm pronouncing that name right. She was suing groups over false CB, and I'm reading for that headline there, or that news report. Mayim Bialik sues groups over false CBD endorsement ads in Florida court. And again, from that citation, quote, according to Law 360, Bialik alleged that the companies used the actress name on their websites to promote fake products such as Mayim Bialik CBD gummies and Mayim Bialik CBD oil to drive customer traffic to their sales page for CBD products. In her complaint, Bialik said she has never given permission for her name to be used and has not been compensated for its use. End quote. Appropriation for personal gain. Intrusion on an individual's affairs or seclusion is another invasion of privacy tort. Two-way mirrors are an example of this kind of intrusion on someone's individual affairs. The Erin Andrews case is also an example. She filed an invasion of privacy lawsuit because somebody had manipulated the lens through which, on the hotel room door, through which you were able to see outside into the hallway. Well, that had manipulated in such a way that video could be taken from the hallway into the room, and her privacy was certainly violated. And she eventually recovered through I believe it was a court verdict, $55 million. Now, whether she eventually ended up with that, I'm not sure, but $55 million was awarded to her. That concludes part one of our presentation on tort law, and we'll see you next time.